Good afternoon, student friends. It gives me a great deal of pleasure once again welcome you all to today's deliberation. In today's session, we are going to discuss about your general principles of contracts. Here I'll be covering, giving the introduction, what are the sources of mercantile law, the formation of contract, how the contract is formed, how the contract is completed, what is the jurisdiction of the contract, what are the essential elements which must be there in order to speak about the validity of the contract, and what about the performance of contract, your payments, appropriation of payments, and if there will be any kind of violation, breach of contract, then what would be its consequences. So after hearing all these things, you will be able to know the different sources. You will be able to understand what is all about mercantile law, what are the different sources, what is the process when we go for the formation of the contract. You can very well explain and what is the how the contract is completed and what is the jurisdiction of the contract, and you will be able to better appreciate the essentials of valid contract and the performance of contract. And if there will be some kind of violation in the contract, then what are the different consequences of breach of contract. So with this, I start with the introduction. When I start with the introduction, I find that every human being, they owe certain obligations, I would say, to his family. They owe certain obligations, I must say, to the society in which they live. So these obligations, they fall under the law of obligations, and they always cover the rights which are arising between the individual and the person on the other side, the collateral in nature, not only the rights but also the duties which are also arising out of it. So the concept of obligation, when we are talking of, it existed since your ancient period, when we had the word of mouth was considered to create a bond. In other words, if I put the same thing, people will never leave from their words. And uh, when I say words, that is your promise. Always you try to keep your promise. So the concept of primary obligation, and in fact, the obligation is one of humanity's greatest moral inventions. So whenever we find that the promises are breached and they will be brought between, or they are brought before the uh, Pancha system for solving or resolving the dispute between the parties because there was a violation. So the law that is applicable to mercantile transaction is called as your mercantile law, which includes your general contracts. Apart from that, also we have special contracts and the law of insolvency and your bankruptcy. So the law relates to the rights and the obligations, those rights arising out of, those obligations arising out of your mercantile transactions between the traders, between the merchants. So we are talking of the movable property connected with your mercantile, that is of two types. Either it is choosing possession or choosing action. So A had a ring on his hand, which is stolen by a thief. A is in person, and A is being a person having choose in possession. But in other words, it means that an individual who had a legal possession of any property of movable nature, and those property physically also visible, and person A can resist the thief from snatching, and recover it in a court of law. So recovering the amount the due on a promissory note is also considered as choose in action. So the right of the payee, who is the payee pays the holder, is not visible as compared to the ring. And further to that, I must tell you that it must also be noted that the law of contract, when we are talking of, that is also applicable to even to non-mercantile transactions. So here it is important to spell about the sources of mercantile law. And when we are talking of the sources, obviously the main source of mercantile law in England, that is your law of merchant, because you know that um, the English people, they have ruled for 200 years. So, or the law of mercantile acts of your parliament or statutes, the common law. So in that case, the second one is the sanction of the state. And when it is a sanction of the state, the most superior and powerful source. And it overrides any rule of common law of equity. So in that case, prior to our Indian Contract Act 1872, the English common law with some modification uh, that was suited to Indian conditions for some time in the British India courts. After the establishment of the courts at Madras, after the establishment of the courts at Mumbai, after the establishment of the courts at Calcutta, and your Hindu law, Mohammedan law, and the law of defendants, they are also to be considered for the purpose of application of law. So the introduction that of the judicial system, in fact, during the British India, paved the way to introduce a legislation, the legislation to recognize, legislation to legalize, I would say, the concept of obligation and the practices among the people by the Contract Act 1872. So that is why the principle of law, when we are talking of the contracts, they are all divided into four categories: the formation of the contract, the contents of the contract, excuses for certain non-performance, and apart from that, your enforcement of contract. So to start with, the formation of the contract. Whenever we are talking of a contract, this is a normal term we frequently use, but from the legal point of view, a contract is an agreement. Not only it is an agreement for the sake of, but it is enforceable in a court of law. So an agreement is a set of reciprocal promises between the parties, between the parties to the contract. So you have set of promises, and the set of promises arises from the offer. The set of promises arises from the acceptance, the offer and acceptance from the parties to the contract. So this contract may be express, or the contract may be implied. So it may be when express, it may be oral, it may be in writing also you can, and when it is implied, you infer from the conduct of the parties, you infer from the circumstances prevailing over there. So it may be bilateral or unilateral contract, and the former one refers to the involvement of the two parties, and the latter one refers to party alone can perform without the other. So when we are using the word agreement, obviously two or more persons they agree, and when they agree, mutually they agree. What do they agree? They mutually agree to undertake to do, or they mutually agree to undertake not to do certain things through an agreement. For example, to deliver goods or to pay for them, this is not through the process of offer and acceptance. Now, coming to the offer is nothing but a kind of proposal. And who is making the proposal? Obviously, it is by the offerer. Why to undertake to do, or why to abstain from doing something, provided the offeree will also undertake to do or to abstain from doing something. Otherwise, it cannot happen. So the offer contains two things, namely an expression, and when you are talking of an expression, it is an expression of your willingness to be bound, or it is a statement of what each party uh, to the proposed agreement must do, or each party to the proposed agreement not to do. So the person making the proposal is said to be called as the promiser. The person making the proposal is said to be called as offerer. The person making the proposal is said to be proposer. So the proposer, offerer, and the promiser is the same. Similarly, the offer is of two types, namely specific offer also and general offer. And the offer is to a specific person, a specific offer. And when it becomes general offer, when the offer is made to the public at large, it is general offer. Suppose A is offering to sell his watch to B, that is specific. Suppose A offers to pay 1,000 rupees to anyone who finds his lost dog, that is the example general offer. So anybody in the society, offer is made to all of them. So anybody who finds the lost dog, if he brings that dog to the owner, so the owner will reward him with 1,000 rupees, which he must have advertised in the uh, print media or electronic media. Now coming to the acceptance, the person to whom the proposal is made signifies his assent thereto. See, so the offer and the proposal has been accepted, and which raises a premise. Obviously, the person to whom the proposal is made, person whom to offer is made, or the person from whom the promiser seeks the assent, he is said to be called as promisee or the acceptor. For example, there is a party named as A signifies his willingness to sell his car for 55,000 to B, and B expresses his willingness, being another party, to purchase the car for the said price. What was the said price? 55,000. So A is the proposer, A is the promiser, A is the offerer, and B is the promisee and the acceptor. So when we are talking of the proposal or the offer or the promise, must possess certain characteristics. And when you are talking of the characteristics, it must be intended, it must be capable of creating legal relationship between the parties so that they give rise to some kind of legal consequences. And apart from that also, the term being used must be certain, and the term must be capable of being certain. And in that connection, it will be appropriate to mention one thing, that the terms of offer must be certain. That means without any ambiguity, without any vagueness. In other words, if I put the same thing, that the person to whom it was made must be in a position to understand. The person to whom it is made must be in a position to respond with his assent. Apart from that, also another characteristics, that is, it must be different from the quotation, it must be different from the catalog, it must be different from the auction, it must be different from the tenders. Because these are all regarded as, when you are talking of quotation, when you are talking of catalog, when you are talking of tender, when you are talking of auction, these are all regarded as some kind of invitation being made, invitation to make an offer. and that to invitation to make an offer for a particular thing specified therein by the person who gave the quotation, by the person who gave the catalog. And if it is calling for the tenders and the auctioning of the goods, that will come under invitation to make offer. Similarly, also, it must be different from your window displays at showrooms. When I use this window displays at the showroom, obviously this is also considered as an invitation to make by the showroom owner from the public. Your railway timetables, issuing of quick tickets by the railway authorities against the payment to whom? To a commuter is amounting to an offer, but the timetables of the railway not regarded as an offer. So that is why when you are talking of this proposal, offer, your promise, most coaches, another characteristics like it must be offered to an individual or to a public at large. Because as I told you earlier, little while ago, the offer is of two types, specific offer and general offer. And offer to a specific person is specific offer. But when you are talking of the offer to public at large, general offer. So as I told you, suppose a person whose name is A is offered to sell his watch to B is specific. He offered to pay 1,000 rupees to anyone as reward who finds his lost dog. That is an example of general offer. So it was advertised in the electronic media and the print media. So anybody, the offer being made to the one at large. So anybody interested, anybody who got the lost dog and you will bring it to the owner shall be rewarded by 1,000 rupees. So that is your general offer. Apart from that also, it must be communicated to the offering because offerer is having obligations to communicate to the respective offering. And that communication must be within a reasonable time. That communication must be with not only within a reasonable time, but also the manner it is prescribed. So in order to convert a proposal into a promise, obviously the acceptance must be absolute. In order to convert a proposal into promise, what we look for? We look for the acceptance, and that acceptance must be unqualified. So it must be expressed in some usual manner, it must be expressed in some reasonable manner. And if the acceptance is conditional and the promisor can also withdraw the proposal before the acceptance becomes absolute, the performance of the conditions of the offer for the acceptance of any consideration for the reciprocal promise to make, which may be offered with the proposal, is an acceptance of proposal. So if you look at the essentials of valid acceptance, obviously the acceptance is not valid if it was communicated in the manner otherwise than which was mentioned in the offer. Suppose it was mentioned that you must give in writing, but you told verbally, then it cannot. Because English law invalidates such acceptance. But if I look at today in 2023 Indian law says that after receiving the acceptance, even if it is in a different manner, the receiver must inform the acceptor that your acceptance is not accepted unless and until it is communicated in the specified manner. Because failing which the proposer accepts the acceptance. So it is to be told. So the offerer in that case may waive the communication of an acceptance, or the acceptance must be made before the offer lapses. The acceptance must be made before the revocation made by the proposer. So it should be absolute. And when I am using the word absolute in terms with the offer, and variation of terms, or there will be some kind of addition of terms to the original offer is not valid acceptance, because there is a statement of fact to an offer, and it doesn't amount to acceptance. So in that case, if there will be lapse or revocation or rejection of offer, then the proposer of the offerer uh, or the proposer lapses. And the lapses on death of the proposer, and that happened before the offeree accepts. So there will be no contract in English law. Even the acceptance was made, and the acceptance was made in ignorance of the death of the offerer. But if you look at Indian law, there will be a valid contract, except I must tell you one thing, that whether where you find that the acceptance is made with the knowledge of the death of the offerer. So this rule will be applicable in case of, you can say, insanity of the offerer also. So if the offeree doesn't respond, and the offeree doesn't respond to the offer in the manner prescribed or within the reasonable time, there will be no contract at all. The term, when you are using that reasonable time, I quote, is used in a wider span, and it varies from circumstance to circumstance of each case. So if the offerer is at the liberty to revoke the offer by communication, and that too at any time, and this is going to happen before offeree makes the acceptance of it. Even if the offer is valid for a fixed term of the fixed period, but the offerer can communicate the revocation of the offer before the offeree accepts. So that is why offeree can communicate his rejection to the offerer, or he may make some kind of counter offer, may also even accept certain conditions. Now, coming to the completion of contract and its jurisdictions, obviously, generally speaking, the contract we are concerned about completes when the acceptance of the offeree is posted, or acceptance is put into transmission, because today also we are using email. So it was made at the place where the acceptance is received. And in fact, by the acceptance is received by whom? By the offerer. So it was easy to determine the completion of the contract when the parties they negotiate in person. But I must say that it will be difficult to determine in case of negotiation, and the negotiation made by post, negotiation made by telegram, negotiation made by the telephone, even negotiation made by the mail. So the contract, in case of instantaneous contract, completes only when you find that the communication of the acceptance is received by the offerer. In other words, you can put it that the contract is said to be made at the place where the acceptance received, but not at the place where it is transmitted. So United Nations Commission on International Trade Law, they have adopted a model on electronic commerce way back in 1996. And as a result, the Information Technology Act, which came in 2000, governs the rules relating to your e-commerce contract. Today we are purchasing using Snapdeal, this Swiggy, Zomato, Myntra. So you are going for e-commerce contract. So the offerer and the acceptor, they are all substituted by the expression of Suri Inato, or the addressee. So you have electronic record sent by the originator, by the that may be received intact or it may vary. And here addressee has to acknowledge the receipt of the electronic record by communication, and that communication is automated or through using any mode or by contract. So the contract completes when the principal place of business, which we are more concerned about, place of business of the originator in case of more than one place of business of originator. So obviously the addressee, the principal place of business of the originator or the address in case of no place of business, his usual place of residence will be considered as the accomplice of your contract for the purpose of jurisdictions. So now coming to the essentials of valid contract, we have consideration, we have capacity of contract, we have free consent, we have legality of consideration, legality of object. They are some of the essential elements of a valid contract. So to start with, when we are using this word consideration, this is one of the essential conditions for the validity of the contract. And when we are talking of the essential conditions, obviously we look at one thing that for the purpose of validity of the contract. So what could be the essential conditions? Because that is needed for the enforceability of the simple contracts, that is consideration. So it is all rule governed and expressed by the Latin maxim. So that means out of we have to understand some kind of valuable considerations in the sense of law may consist either some right or some interest or some profit or even in terms of benefit which are accruing to one party or even in the negative form some forbearance, some detriment, some loss, some responsibility suffered undertaken by the other. So an act of forbearance of one party or the promise thereof, that is the price for which promise of the other party is purchased, is bought, and the promise thus given for the purpose for some kind of value that is enforceable. So when at the desire of the promisor, the promisee or any other person, what they do, they have done or they have abstained from doing, they have done positive, affirmative, then negative, abstain from doing, abstain from doing, so or promise to do or abstain from doing something. So such kind of abstinence promise is called the consideration for the promise. So if we make an analysis, for example, suppose we say that the consideration may be executed or executory. In a contract to deliver a watch by A to B for 1,000 rupees, A and B gained money and watch, and in another stand, A and B lost watch and 1,000 rupees respectively. So the law insists more often one thing that the presence of the element of detriment to the promise B and then the presence of benefit to the promise A, if we look at, so obviously the promise that we are more concerned about is a promise of one party to the other and the promise from other to the former in support of the consideration. In other words, there is reciprocity of promises between the parties, establishes parties, those who establish the consideration. And in the, suppose there will be absence of consideration, the absence of consideration makes the contract void. So there are certain principles. The principle has certain exceptions. What are the principle? As I told you, the absence of consideration makes the contract void. But the exceptions recognized under the provision of law, they are whenever you go for a contract and the contracts reduced into writing, reduced into register, and you make out of your that contract out of your natural love and affection between the parties, those parties standing in near relationship to each other, then that case it will not happen. Promise is made by a to pay the time bar debt does not create a fresh consideration. Sometimes a gift between the two parties, one is the donor and the donee, is not affected for the want of consideration if it is registered and attested by two witnesses. So, though consideration is necessary, I must tell you that it did not be adequate. That means the adequacy, and that means your sufficiency, adequacy of consideration, sufficiency of consideration is immaterial. That is immaterial. So it is always said that the paper call is sufficient for the purchase of an element. So you cannot give something for getting nothing. So the consideration is to move from whom the question is to be determined for the purpose of its enforceability by court of law, enforceability of the contract. And it must proceed from the promisee, it must move from the promisee. So under the English law, a stranger to a consideration cannot sue, cannot file a case. But in other words, promisee cannot sue the promisor, provided the consideration doesn't move from him. Under the Indian law, a stranger to consideration can sue. Now, if we look at the consideration and the discharge of a contract, there is a doctrine of consideration that is not extended to the discharge of contract. So here, what we are more concerned about, we are more concerned about the reciprocal promises between the parties. The parties, they constitute considerations. So that is the case by subsequently, if we find that if both the parties, they agree not to enforce the contract, also they constitute consideration, no point of doubt in India. But it is also not in English law. Till 1947, the law of England applied the doctrine of consideration, not only to the formation of the contract, but also to its discharge. So it was all pointed out that a creditor might accept anything in satisfaction of its debt except a less amount of money. So that is why a canary or the peppercorn may be accepted in full discharge of a debt, but a part payment, if you are talking of the debt, cannot be accepted as so as to operate as full discharge of the debt. So that is the case. We also must talk about as the characteristic, that is the capacity of the contract, because there are certain persons in law, what we look at, who are incapable, either wholly, who are incapable or in part of binding themselves by a promise or enforcing a promise made to them. Because if you look at the mercantile contracts, obviously we find that the law of the place will prevail. Whereas in case of land, the law of place where the land situated will be applicable. So incapacity of a party, party to enter into a contract will arise in two ways, namely on account of status, or you find that on account of your mental deficiency. So the former would occur on the ground of political consideration or your expediency, and the latter is imposed to protect the interest of some kind of disabled persons. So the capacity of the party, when we are talking of, it is divided into two. One, party, it arises out of your status of an individual for certain reasons. Reasons could be your political status or the civil status or the profession of contracting person, like doctor, barrister, or incorporation or marriage. But the other arises from your mental deficiency. And when you are talking of mental deficiency, that speaks about the soundness of your mind, of the person. Contracting in case of minor, contracting in case of insane person, contracting in case of your idiots or drunken persons. So the persons below the age of 21 is called minor. Uh, and infant, I would say, as per the Indian Relief Act 1874 under the common law. And below 21 infant, below 18 is your minor. Person below the age of 18 is a minor, as per the Family Reforms Act 1969. But if we look at the English law and the Indian law respectively, uh, he is a person who is not a major as per Infant Relief Act 1874, which is modified to your common law of England, allows even infant to enter into a contract for the necessary or for beneficial contracts or the contracts involving recurring rights and the duties. For example, interest in property binding. And we have, in this case, in case of a contract, we should have mutuality of mind. The parties to the contract must have consensus adi them, meeting of minds, which means your mutuality of minds so as to make the subject matter of the contract. If there will be lack of mutuality of mind, makes the contract void. So suppose A had two houses, X and Y, and A enters into a contract with B for selling, for sale keeping uh, X house in his mind. B entered into contract, A by keeping Y house in his mind. So this results into that contract is totally void due to lack of consensus are the parties to be in full and final agreement, and they must understand the same thing, same sense at the same point of time. No, it cannot be different thing, different sense at different point of time. So in this case, no, you will be getting free consent. The consent of the party of the contract is said to be free. When do you say that the consent to the party is said to be free if it is not caused by coercion? The consent of the party is said to be free if it is not caused by undue influence. Consent to the party is said to be free if it is not caused by fraud. Consent is said to be free if it is not caused by misrepresentation or if it is not by mistake. If it is not caused by mistake. Coercion. Let us discuss one by one. Coercion. Committing to crime, threatening to crime. Any kind of act which is forbidden by Indian Penal Code 1860, unlawful detaining or threatening to detain, property to prejudice, or there is an intention of causing damage to another party. So it is mostly physical in nature. So the presence of coercion, both Indian and English, was invalidating the element for the enforceability of contract. Similarly, when you are using this word undue influence, this was also called as constructive fraud. It covers all the contracts when one party, in fact, will be um, in a position to dominate the will of the other because the relationship is such while entering the contract, one party is in a position to influence. So the influence can be presumed in existence from the relationship between parent and child, relationship between trustee and beneficiary, relationship between lawyer and client, relationship between guardian and ward, relationship between spiritual master and disciple, or doctor patient, or master and servant, because the contract between the parties with relationship turns it voidable by presuming that the existence of undue influence of the former against the other. So it is the burden on the former party to prove that it was not in dominating position and that too his position was not used to obtain the consent of the other. Similarly, when you are using this word fraud, the following acts of a party to a contract establish fraud while entering into a contract with other, suggestion of a fact which is not true by one who doesn't believe it to be true, or some kind of active concealment of facts, material facts, by not having knowledge or belief of the fact, promise made without intention of performing it, or any other act fitted to deceive, cheat, or any kind of act or any kind of some omission, as the law specifically declares as fraudulent. Sometimes also it would be appropriate to mention over here that your mere silence on the part of the party does not amount fraud, but silence amount to fraud where there is a duty of the party to speak. Similarly, if you look at another characteristic, that is your misrepresentation. A party may give his consent to enter into a contract because of misrepresentation of the other. That means there is a false statements. It will be either inducing cause of contract, and these statements may be called as innocent misrepresentation, or you can say willful misrepresentation, actionable misrepresentation. And these amounts of fraud, because misrepresentation consists of failure to disclose of any kind of fact which is material. Such disclosure must also relate to a fact, not to an opinion. And such representation must be untrue. That is also another aspect to be seen. And it must be material fact to influence the other to enter into a contract. So any representation, if at all it is made by a party, and when it is made with full knowledge of the fact that you can say it is not true, then in that case, or it is without belief, or it is made recklessly, not caring the falsity of it, whether it is true or false, it is always said to be fraudulent. Similarly, you can talk about the mistake, because while entering into a contract, the parties of the contract may be under a mistake. This mistake may be as to fact, this mistake may be as to law. So there is mistake of fact, which may be the subject matter of the contract. For example, regarding the existence of the quality, regarding the existence of the quantity, nature of contract, person entering into the contract, or mistake of law may be regarded as for law, your ordinary law, law of our country. Another classification, this mistake may be bilateral or it may be unilateral. Whenever there is a mistake, and that too mistake of fact in the minds of both the parties, negatives the consensus adidem, and the contract in such case is void. But when the parties to an agreement, there are mistake as to the matter of fact that is essential to the agreement, and that case agreement is void, and this will come under bilateral mistake. Similarly, you have also unilateral mistake, when only one party to a contract is under a mistake, and that too on contract, generally speaking, is not valid. A contract is not merely voidable because it was caused by one of the parties to it being under mistake as to the matter of fact. So contract is not at all voidable because it was caused by mistake as to any law in force in India. But one thing that is certain, that the mistake as to the law not in force in India, you have the same effect as the mistake of law. And similarly, you have also legality of considerations. And when you are talking of legality of considerations, apart from the discussion made earlier, the formation of the contract, that to valid contract, the legality of consideration and the legality of the object is must. The unlawful agreements may be classified as illegal. The unlawful agreement may be classified as immoral. The unlawful agreement may be classified as opposed to public policy. Illegal when the agreement is contrary to the statute of law. When you talk about immoral, when it is opposed to public morals. For example, A is signing an agreement with the B for illicit cohabitations. A is the husband, B is the wife. They entered an agreement. What was the subject matter of the agreement? Object of the agreement, legality of the agreement, separation between husband and wife. And when you are talking as opposed to the public policy, where you find that the agreement is forbidding as conflicting with the well-being of the state. For example, you go for some kind of agreement where you find that the agreement tending to the abuse of legal processes, or agreements in restraint of trade, agreements in restraint of marriage, or agreements in restraint of parental rights. No. So this is also unlawful agreements, different way it has been classified as illegal, immoral, and your as opposed to public policy. So when a part of the consideration or when a part of the object of an agreement is unlawful, obviously the contract is void. And in case of non-separation of the unlawful agreement from the agreement, that the total transaction will be void. So the rule which is applicable to separate the unlawful and lawful, that is the rule of blue pencil rule. So in all these cases, what we have seen that what is material to the entire discussion, that is the performance of contract, because both the parties to the contract either perform or offer what? Offer to perform their respective promises until such a performance is dispensed with or, or, or excused under any provision of this act. So obviously, even the death of the party makes its legal representatives liable unless the intents of the parties to the contract they differ. So the promise is non-acceptance of the offer of performance of the promisor. Then in that case, I must tell you that the promisor is not responsible for the performance, nor does he lose his right under the contract, and that too subject to conditions like offer must be unconditional, it must be proper, specific, and if it is the delivery of anything that is to be made to the promisee, so he must have an opportunity of seeing and delivering things which the promisor is bound by his promise to deliver. So in case of anticipatory breach of contract by the promisor, obviously the promisee may put an end to the contract and sue for the damages immediately, though he had the right to keep on the contract until the performance is actually done. So keeping the promise alive, you may lead the promisor to take advantage of certain supervening, I would say, circumstances, and those circumstances which are beyond control. So in this case, the time and place of performance is important apart from the performance of the reciprocal promise. But one thing, it is clear from our discussion, there is doctrine of frustration, or you can say agreement to do impossible act. Because I must try to tell you one thing, that the agreement between the two parties, when it is made, and if it is made to do an impossible act, itself it is void. Suppose I will tell you that I will give you 5,000, 5 crores of rupees, you jump from 10-story building. So you know what would be your consequence after jumping from 10-story building. So a contract may also be void because of some kind of agreement which makes the performance of the promise impossible, which makes the purpose of the agreement is unlawful after the completion of the contract. So that is why any person who makes promise, in fact, to perform by knowing it to be impossible or unlawful, is liable to pay the consideration to the promisee that is not aware of so far as impossibility or unlawful nature of the contract is concerned. So this will be applicable in case of two cases where the supervening event, in fact, you can say, makes the performance of a contract impossible. In another case, you find that when the supervening event or the events have frustrated the object of both the parties and the changing circumstances, the promise fails to be performed. So you'll have disclosure of not only disclosure, but also you have the dislocation of the business in the wake of the First and Second World War, in brought before the court a large number of frustration. That means cases were developed, and it was now been recognized. This term frustration includes the case of impossibility as well as the frustration um, of adventure. So in all these cases, supervening impossibility, and we must also look at its legality part, whether it is illegal or legal. Now coming to the appropriation of payment, when the payment is made by the debtor, the payment has to be remitted by the creditor towards the amount and the outstanding amount as suggested by the debtor. And if the debtor is not specified to which the debt, to which debt the payment is to be adjusted, so obviously the creditor has a right and right to pay, and had a right to pay even the time barred debt also. Neither the debtor nor the creditor, they appropriated the payment made by the debtor. So the payment must be adjusted. That is of my opinion towards the first debt, which is outstanding between the creditor and the debtor. So you can have contracts which need not to be performed. As I told you, performance of contract is well and good, but the contracts which need not be performed, original contract, we look for the original contract, and the original contract between the parties and not be found in case of novation, in case of recession, in case of alteration, because such I would say situations, uh, we have to be more reasonable enough to see how the things can be taken care of. If the parties, they agree to substitute a new contract instead of the original contract, obviously he has to rescind the contract or to make some kind of alteration of the contract. And the parties to the original contract and need not perform the original obligations in that case. So, in all these cases, we have certain quasi-contract. Quasi-contract literally is not a contract, but circumstances as such, contract is created. Suppose A and B, they are two friends. B invited A to come for dinner. A said that I'll be closing my shop little late. Then afterwards, I'll go to your house to have the dinner. But since A is the trader, he carried certain articles with him. He kept hard meal. Discussion was made. Then 15 minutes to midnight, he left. But when he left the late hour, by mistake he left certain articles belonging to him in B's house. The next morning, B started considering those as if they are their own. Then in that case, he can keep, but he has to pay the amount to A. So there are certain examples of quasi contract: action for money had and receipt. And this was based on the equitable principle, because as I told you, A and B two friends. B invited A. A is a trader for a dinner. A said that yes, I will reach your place little late because I will have to close down the shop. There should be accounts reconciliation. So I'll be little late. So as a trader, I reached little late. And when I reached, I also carried certain articles because I was en route to my home. And when he left, after having dinner, chit-chatting, discussion being made, by mistake he left his uh, tiffin box as well as certain um, articles which are costly. He was carrying to his own house. The next morning, B started thinking, considering those goods as if their own. Then in that case, if B is talking about that, he has to pay for the entire money. And then only he can keep. So never A sold, no intention was there. By mistake left. Next morning B started treating those goods as if their own. In that case, court says that you have to pay for it because contract without consideration is totally void. Of course, there are certain exceptions like your trust, marriage, beneficiaries are all there. So there are certain examples of the quasi contract, like the action for money had and the receipt. Money paid to plaintiff for use of dependents and the quantum merit. And when you are talking of quantum merit, the person who has derived benefit from the act of another has to compensate the other, even there is no contract or invalid contract. Similarly, obligations of the fund of the last goods, apart from necessary supported or necessary supplied to a person incapable of contracting. Now coming to the last one, that is your breach, violation of the terms and conditions contained in the contract. So what would be the consequences of those breach? So any party who is responsible for breach of contract obviously is liable to pay payment for what? Payment for damages. So he'll have to compensate. So compensation to the other party. Who is that other party who is suffering loss because of the non-performance by the other one? So in other words, party who did not receive got affected, known as aggrieved party. So party aggrieved by the default of the uh, performance of another liable to pay for the damages. And this leads to the breach of contract and entitlement, entitles him to compensation. So there are two remedies available in case of there is a breach of contract because we have common law. So the remedy for damage therefore tries to evaluate in terms of money and the loss which a party sustains as a result of breach of contract. So in that case, major damages is the value of performance of the contract to the plaintiff, and in that case, these are all not what cost the defendant to perform it. The general damages, substantial damages, or the uh, uh, vindictive or exemplary or the nominal damages that we are more concerned about. And in this case, um, the you have to pay for it as a regard against the compensation, and it should be more than the agreed. Sometimes the damages or the injured is not uh, disentitled to damage because of difficulty to assess them. So with this, we come to an end of today's session. Thank you very much. Have a nice time. Good day.